in Sarasota County, where they offered me
Here
a
we
full.
go.
Oh,
Here we go.
hello,
No, no. I haven't
we're
seen it pop
live.
up yet. We're live. All
We're
right.
live.
Very good. And this is Curt and
Brad Pinsky, and we
we're
got
here for
caught off guard.
I have I'm going on about 4 hours sleep here. So but we're here for another edition of Fire Law Roundup for July 14th. We're halfway through July of 2025.
Perfect. So let's start in Florida, Miami-Dade, and let's start with creepy is as creepy does. So we covered this previously, but now we know who it is. And here's simply what happened. A lieutenant back in 23, I believe, is accused of planting, alleged, accused, he's charged, not convicted, accused of planting two cameras, one at Station 69 in Miami-Dade. I think it was the men's bathroom was in that one, and then in a woman's bathroom in another one where he caught 18 separate victims, male and female combination. He recorded them without their knowledge. Obviously, no matter what state you're in, there is probably no legal right and absolute prohibitions to putting cameras in bathrooms and changing areas. And certainly there are not too many states, I imagine, where you could do that without anyone's knowledge and where you're not a participant in the conversation. In any event, he has been charged now. And I think they're felonies because he's already spent some time in detention as he awaited bail or something. In any event, they caught him because though they didn't see his face. It's interesting when the individual was adjusting the camera and they reviewed the camera footage, they saw a watch which was identical to the one owned by or worn by this individual. So they have since caught him. In any event, these are allegations. He's not convicted. He was held on a $27,000 bond, but is out because if you watch the recording, they show him walking out of the detention center. Anyway, that's don't do this. I don't know that
Well,
we need to give a lot of legal advice.
no, and as you were talking, it was something I meant to do before we got on the air this morning, this afternoon, and I want to throw it out to you. How many cases do you suppose I have in my database of facts that are
Oh God, I
similar?
gotta guess like 50, and I'm
Hmm.
stretching here, but I know it's not infrequent.
103.
Oh my God. Okay.
103. Now, that's total cases. So, some of which involve discipline, some of which involve criminal, some of which involve a firefighter suing someone for invasion of privacy. But 103 of surreptitious filming in the firehouse of this type of nature, whether it's a locker room, bathroom, changing room, private dorm room, 103 cases. 25 of which are criminal. Now, some of them you could have typically end up with several cases arising out of this. You end up with the criminal charge, like we see here. You end up with a disciplinary action against the firefighter. And then sometimes there's a civil suit against the firefighter and the department arising out of it. So that's how we end up with 103. So, yeah.
Don't do it. Anyway, the employer shouldn't even do it for valid reasons, right? But if you're ever
Well,
gonna,
you got to be very careful as an employer, even if you've got like you suspect somebody of stealing, you got to be very careful about where you got to check with legal before you do it.
yeah,
But
yeah.
you
I
got to
mean,
be
there are
very
posting
careful.
required. Look, this is surreptitious. This was not like an employer trying to do it. This is not the department. The department fully cooperated.
Mhm.
It seems lately like Miami-Dade can't stay out of the news, but
That's a
they
big fire department. It's a big fire
it
department.
is.
They deployed to Texas. I mean, they're an international urban search and rescue, and you know, they're
Yeah.
really a leadership department, but they're massive. The size of the department is
Oh yeah.
massive.
Yeah.
So.
And speaking of deployed to Texas, I imagine it's going to be very interesting as everyone has seen, the union came out totally separate, not one of these, but I want to predict as the union came out against their fire chief, I think 2-year fire chief, for not sending their swiftwater rescue team close to them. I think that was in Austin, and they weren't the flooding wasn't so far away that they have one of the best or the best allegedly swiftwater teams in the state. They didn't send them. The union went right after right after the fire chief. It is going to be very interesting to see whether there's going to be discipline, retaliation, and then First Amendment claims by the union, et cetera. But
I am friends with the fire chief,
oh,
and I am friends with the union president in Austin, and I'm like, I am staying out of this
stay
one.
away from it. Right. I
Yeah,
would not
I have
comment on
respect for
it.
both of those men, and it's it's unfortunate. So
Right. And there are allegations in that. But anyway, so that's been interesting news. Didn't mean to throw that in, but since you
yeah,
mentioned Texas and flooding.
yeah, yeah.
Okay, let's go to DC. I just want to predict on this, you lose. Not you, Curt, but you people suing. They should probably do a lot of research on this. I'm sure they have.
I
Bay
think they
versus
had,
New York.
I think we covered a case. Well, where was it? Where was the case that the firefighter just won? It was
Oh,
like,
well, the mechanic case? The mechanic
no,
case.
no. He was an air supply, Atlantic City, the air supply technician.
Yeah, yeah. Oh, right,
Yeah,
right.
yeah,
That
the
case.
air supply technician, and he's a firefighter assigned, but he hadn't had to wear his pack and all that. And well,
Very different.
but you know what? People who stay at the headlines,
Yeah,
they read the headlines, say, "Oh, they're going to allow firefighters now to have beards," and they don't get into the nuance part of it. And
yeah,
I kind of wondered whether or not that was going to, because our headline, how we've talked about it here,
right.
but there's some other blogs and some other traditional news media that is covering it in a different way. And they're saying sort of the courts have reversed course on it. So
No, and yeah, and let me give the facts here, but anybody who's part of the suit probably should have looked at BEY, Bay versus City of New York, which is only a number of years ago, maybe 3, 4 years ago, where the Second Circuit held that following OSHA requirements is not going to allow race discrimination, disability discrimination, or other failure to accommodate actions, and then isn't going to support a retaliation claim. But here we have 14, we have two separate groups, two separate lawsuits, identical basically, but two separate suits of 14 firefighters, I think, challenging the DC Fire Department's no beard rule. They're interesting. They say you can have a quarter of an inch. I think
yeah.
OSHA's new regs is nothing, clean shaven. That's what led to Bay versus City of New York, where they held the black firefighters had to shave as many times a day as it took, all firefighters, but it affected the black firefighters who have a folliculitis condition where shaving too much causes severe and painful irritation. Here, it's more based on the fact that they allege race discrimination, religious discrimination, but I want to focus on retaliation. This is a novel one. So, they're saying, look, we have to wear, we have to shave and we don't want to comply with 1910-134, with the, city's rule, which is based on 1910-134. What's interesting in this case, let's at least give some credit to interesting, is remember, you can lose a discrimination case yet still win on retaliation. You can, right? You can claim, well, I was discriminated against and lose. The court finds there's no discrimination, but then find, but we were retaliated against for making the discrimination claim. This isn't exactly that. This, best I can read the complaint, is that both complaints is that they're claiming that the city's using this quarter-inch shave rule in order to retaliate against them. And that's a little different than saying enforcing the rule is discriminatory. They're also saying that. So I don't believe they'll succeed, but maybe they'll succeed on, at most, the retaliation claim, saying you're enforcing the rule to retaliate against us. But if they're enforcing it across the board, it's hard to prove retaliation.
I think one of the parts of the retaliation claim I thought was interesting, and my mind started spinning up on this one about how you'd prove it, disprove it, is that by taking a firefighter and sending the firefighter to an EMS assignment,
Which is what they claim.
that's retaliation. And I'm saying, well, if I'm the attorney for
That's
the city,
accommodation.
well, yes, exactly. But I think what I would say, yeah, they could be just let go, or but
Right. Insubordination.
so
Right.
but I think that the lawyer in me now is saying, okay, if I'm representing the city, how do I go about proving that EMS assignments are not punishment? Okay. And certainly firefighters are going to testify that, yes, that's punishment. Nobody likes to do it and all that. But then you bring in like folks like yourself, like you spent a lot of time in an EMS organization before,
Yep.
even in law school and then,
Yep.
in your undergrad.
Yep.
And bring in someone that really enjoys EMS and have them testify, do you feel being assigned to EMS is punishment? No, that's what I enjoy. That's what I like doing. That's not punishment.
And think of it, it could be benefit because I don't know how DC structures this, but if their EMS like FDNY EMS is separate from the fire department, so they're 40-hour employees, not 56, 52,
Oh,
whatever hour employees,
yeah.
maybe they get overtime for their extra shifts. I don't know how EMS works, but you could argue in some cases it's a benefit, but it is an accommodation.
Right. And I think that's the important thing. And another thing was originally back in 2000, you and I covered this case. Back in 2000, at the beginning of COVID, the city got out from under that crazy decision they had from whenever it was, the 1990s or early 2000s, where a court had said that they can have beards. So they got out from under that. But then they didn't do it right. They didn't go to the court and get the court to overturn the earlier decision. They just decided to sort of do an about face on it. But at any rate, the city came out with a policy that said no beards, period.
Right.
Then as an accommodation, they said you can have a 1/4 inch beard. Okay, so that was an accommodation.
Yep.
And now these guys are turning around saying, well, you let them have a 1/4 inch, why not 3/4? You let them have three
Right.
quarters, why not an inch?
Right.
Now you've
Yeah, and if I was them, I'd say, you know what, forget it, which could be viewed as retaliation, but we're going to
yeah,
stick to OSHA's 0, no growth whatsoever, because that you and I looked at with John and Chip on the fire engineering podcast, right? Their recent memo is 0.
yeah.
So, I
Again,
think,
I don't want to be viewed here as us taking sides on beards. Obviously, you have a beard. I've got
but I'm not interior now, so
I've got some facial hair growth, and I got to kind of be careful about my fit test and so on. Okay, but we're not taking sides in this. And I think the solution, I hate to sound like a broken record, the solution is for NIOSH and the manufacturers and the NFPA, whomever has the funding for it, is to do additional research to determine if new mass technology will allow beards. And if it will, then fine. But the solution is not the
or
courts.
go to the European model, and then it's not an issue, right?
Well, but point being, we keep trying to use the courts to solve something that, I mean,
Science needs to.
the IAFF could push this at the national level and say, we want a definitive answer. Is it possible to create a mask? And is it within the capability of the manufacturers to develop a mask, or do current masks allow for beards? And if they do, case closed. If not, case closed the other way. But to try to litigate this and try to say, well, it's race discrimination, it's religious discrimination, it's retaliation, I'm a whistleblower, you're picking on me.
It's federal regulation.
Yeah,
I mean,
yeah.
that's look, I think Bay said it right. If you're following federal regs, that's the end of the story. It can't be discriminatory to follow regs and implement no matter what your reason, even if it's now I got you, I'm going to enforce federal regs, that can't be retaliation. It's the law. And people may not agree with it, right?
Right.
And
Obviously, they
science
don't.
may not support it. But it's still the law. Even if science says, oh, the positive pressure mask seal with 2 inches of growth,
Right. Well,
it's still federal law.
and again, I guess my assumption is once the science has changed,
And maybe the law will.
then the law will. Okay.
Right.
But
Maybe.
yeah,
Maybe.
maybe.
Right.
I would think with the political pressure that the IAFF could put on it,
Yes.
they certainly could.
Okay, so now let's go to California. This is a good, interesting thing. So, this is a good example of, you don't want to play gamesmanship with personal grievances, and you don't want to let personal grievances win the day, because in California they just cost $4.1 million. So here's the summary. Everyone, I really encourage you to read the blog post in full, but let me summarize it. So we've got, and this is an appeals court who affirmed a jury award. This is not getting overturned. 4.1 million damages was granted to a West Covina's former fire chief, Larry Whithorn. Congratulations to him. I'm not taking sides, just, he won. What can you say? He was terminated following a prolonged medical leave. And the short is, we got a city council member, let me summarize this, the most basic facts, who said, I want you gone. And the original city manager would not get rid of him, wasn't playing in those reindeer games. And so they get rid of the city manager, right? Trying to get rid of the fire chief. So they get rid of the city manager. They try all sorts of things. We're going to amend our regs. We're going to amend our rules. We're going to try to give certain powers to somebody to get rid of the fire chief. Ultimately, they get a new city manager. And after like 2 weeks, the new city manager comes in, steps on his toes in an apparent, I don't want to say lie. Let's just say his testimony wasn't so consistent, and the jury picked up on it, where he said, "Oh, the reason I got rid of you in just 14 days or so was because I had some observations of you," and then that contradicted his other testimony previously given. The jury didn't buy it. It looked like a personal vendetta of this council person who now is supported by this new city manager. In any event, they got rid of the guy, the fire chief, for questionable reasons, something in his personal record, something I observed. The jury didn't buy it. Kudos to the jury, frankly, and said, you're terminated improperly. The fire chief was improperly terminated. Even the HR department cautioned them and said no, and they got rid of them. Just vendetta after vendetta. This is not good. When you get a lot of people telling you you should not be terminating somebody, and exceptionally, if it's your HR department and your former city manager, maybe you shouldn't do it.
This is one of those stories. I know I've said it before. Again, a broken record here, but we have elected officials who come into office and become like petty tyrants. All right. And you think about it, you own a business, I own a business. If I make a business decision to hire or fire or, end a contract with a vendor or whatever it may be, my investment is at stake. My life's work, my bank accounts, everything's at work. These idiots get elected and they're gambling with other people's money, right? They're basically playing poker with other people's money. And this elected official, he didn't have to pay the 4.1 million. And it makes me wonder whether or not, to kind of prevent this kind of nonsense, whether or not there needs to be some sort of personal liability on elected
There could be
officials.
under Monell, which is that he's a policymaker.
Right.
I don't know if they did. You can name them personally and
And
individually.
it's tough, and we know
It is tough.
Monel is tough. It's very difficult to kind of hold them personally liable.
But here I would have argued, I don't know if they did, right? Because that doesn't look to be, but I would have argued. So Monell, so everybody knows, is a claim under the Constitution which says the city or its board, governing board, has a policy of something. And here I would have said has a policy of harassment. And here, because there were so many acts, ignoring your HR, firing your city manager to bring a new one in only 14 days, one of their first acts is to get rid of them, I think you could have established Monell liability. And it seems like the city council endorsed that by allowing all of this. They could have ended it, and they didn't. And it looks like by firing the old city manager, hiring a new city manager, right? It looks like a policy of harassment. I don't know. I think, look, they don't care. They didn't want to sue this person individually. He doesn't have $4.7 million.
Right. But I don't know. It just it infuriates me when I see this kind of stuff going on, and who suffers? The taxpayer suffers. Right. By somebody, some guy who gets himself elected, and he's going to be now a petty tyrant. And I don't know. It's just, to me,
I agree.
That's infuriating.
Yep, so. I agree. It is, and he wastes it. But anyway, hopefully he gets fired. Because, I would fire somebody who just cost me 4.7
Well,
million,
you
in
got to
my
vote them
opinion.
out. It's not a question of that. Certainly the city manager, yes, but
Oh, yeah, right. He has to be
the
voted out.
elected official, and I think it's harder to hold elected officials liable under Monell. And you could try to go on a different constitutional theory. Monell is for policy
All
decisions,
right.
but where someone does something purposefully, you
Official
don't
misconduct.
necessarily
Yeah.
need to go under Manel. You can
Yeah.
allege a direct constitutional violation, but I don't know. It just it's frustrating, you know.
It is. It is. Okay. Something that's not frustrating, however, is that the Department of Justice, and I think this is going to become more common. Not
Yeah.
that I know how many of these, but the Department of Justice on their own, and this I think is a Trump issue, right? The Trump era DOJ has asked to end a 47-year-old consent decree in Norfolk, Virginia, right?
Right.
So back then, way back, there was much fewer black and female firefighters and police officers. Since then, they've gone from 4% to 10% in the police ranks, from 1% to 11% in the fire ranks. And by the way, the career statistic of female firefighters is 8%, right? So they're doing well. I don't know what the traditional number of black firefighters is now, but now they have 19% police officers are black, 15% of firefighters are black. And so they've met the 50% interim goal. And they say, listen, it's not needed anymore. As you well point out, look, if it becomes a problem, if they back off it, DOJ can go another way. I don't think this is a DEI issue. I think it's just we just don't need it anymore. So let's get rid of it. Let's clear house of
It's
these.
it's a carryover and it's a burden to the community. Every time they go to hire, they have to take certain steps, and there's a lot of departments out there that are still under 40, 50, sometimes even longer consent decrees. And we see from time to time, we see them being rescinded. But you can't just stop doing it. If you're under a consent decree, unless it's got some sort of a time limit on it and it ends on a certain date, you have to go back to the court. And if you fail to, somebody who didn't get hired that feels they should have under the consent decree can take you back to court and have you found in contempt. So
Yep. Yep. Okay. So last one is confusing. Understandably, it's right down the street for me. So as I am now, I'm momentarily. Well, I'm right now in Sarasota County. Right next to me is Manatee, and then West Manatee. So this is right next to me. But it's confusing. So start with there is a difference in many municipalities, not just down in Florida. That what Manatee County is Florida, kind of the West Coast, Midwest Coast. For everyone who goes to VCOS and such in Clearwater, this is kind of like half an hour under that. In any event, there's an issue. The fire district imposed question, is it a tax or an assessment for short-term vacation rentals? And this owner of a short-term vacation rental property sued the fire district. They claimed that the classification of these short-term vacation rental properties, the district called them commercial properties, and they did that for the purpose of calculating a non-ad valorem fire assessment. So an ad valorem fire assessment says the higher your tax or higher your valuation of your property, the more tax you're going to pay, right? Some Pennsylvania and others, they call them mill rates. And right, so you're taxed on the valuation of your property. If it's higher, you pay more taxes. And so a bigger, more expensive property pays more. Alternatively, assessments in some forms, commercial assessments say, well, your property's bigger, you're going to need more services. So they claim that the fire district imposing a commercial valuation, not on an ad valorem basis, but was an assessment and it was unlawful. I hope I'm getting this right. And they argued that it was an impermissible regulation of the short-term rentals and trying to disguise it as a special assessment. The court didn't agree. The court allowed the fire district to tax it or assess it as it should have been. And they held that the district was within its legal rights when it imposed a higher assessment based on property usage, not based on property valuation, right? So a smaller property could bring in more money. And so they said, listen, you have people in here. So there's code issues, code enforcement issues, et cetera. And you're allowed to assess it in the way you're assessing it. I think I've done that justice, but sometimes, without spending 30 minutes reading these court decisions, it's difficult. But the court really goes into the difference, and this is very Florida specific. Not all states and municipalities tax this way, but they looked at, look, should it be on an ad valorem basis? Should it be on a usage basis? And they agreed this could be done as the fire district did it.
Yeah, and I think there's a bigger issue here that affects most states, and it has to do with the classic Airbnb model. And when Airbnb and some of the other models like it first came in, folks were starting to market their house, might be a guest house or an in-law apartment or whatever. But the question became, can the municipality treat it, either prohibit it entirely, or can they regulate it in some way, whether through zoning, and you can't do it here, you can do it there. So the next thing that happened was many states enacted state laws, because you think about it, for Airbnb to go to every municipality and make sure that a municipality doesn't enact that kind of a law, there's not enough attorneys, advocates to go make sure that happens. So what they did was they went to the state legislatures in the 50 states and said, we want a state law that prohibits municipalities within the state from enacting laws that regulate or prohibit Airbnb usage. Okay. And many states did. Florida was one of the states that did. But the big question now is taxing them in a way that makes them commercial considered a way of regulating them. And that was one of the arguments that was made. And the court said, no, that's not they're not trying to regulate it. What they're trying to do is recoup some of the additional costs that this type of a facility burdens the municipality or burdens the fire district. It's more demanding of services or whatever it may be. And the court said, yeah, we're not going to, this isn't a regulation, and it's
Yep.
reasonable.
Yep. And that's really the end of it. Most importantly, that's the end of this week. And it's fun ending a week because you never know what the next week is going to bring. But I want to tell everybody this. I just lectured with one of our friends, John Murphy, in Sarasota County, Florida, for a couple of days. Thank you to I hope you guys are watching, but thank you to Sarasota County. You were so gracious. And man, their fire chiefs, they have a whole new administration. Their fire chief and chiefs are just such a great group of people. I don't think we ever see Sarasota County. I hope not. I told them keep my taxes low. We don't see them in our news much. But anyway, they were so great. But I told him, I said, if you will watch us for about 3 consecutive months, you will be so far advanced in your understanding of how to prevent discrimination, what not to do, what to do to win. And, I lectured on discrimination and other issues, how to prevent it. And so much of it was just look at Curt's blog. And it's surprising how many people know you, by the way. It's scary. You've obviously been doing this a while. But no, I've said this 20 times before on our show, but I really think if fire departments are serious and they want to cut their liability, watch this show for 3 months and you will see that there are ways to not screw up and do things right, or there are ways to be vindictive and lose a $4 million lawsuit. So
you start seeing patterns, and that's what caused me to start my database. I started seeing patterns, see a case, and then a couple of months later, I'd read another case. I say, oh, that's the same case. And then I'm like, oh, no, wait a minute. That one was in Oklahoma. This one's in Colorado. Those are 2 cases, same facts, same issues, same mistakes made. And so, to manage the Alzheimer's that's out there, I started the database to kind of keep track of all this stuff. And then it's just sort of grown from there. So, and I got to thank the folks in West Manatee for feeding me this case, the last case that we talked about. I taught down there just before COVID. I was down there, and a good bunch of guys down there. So, but at any rate, they they were the ones that let me know that they had prevailed.
Well, if they're watching, thank you. And by the way, I'm right here. So if you want someone to come lecture on some good
Hey, no,
stuff,
wait
or
a
you want to
minute. Now,
bring
wait a
Curt
minute.
down, even better.
There's planes that fly me down there. I can come down.
All right, so come on down.
I'm
Allow
coming
me
down
to
to
see Curt.
Bradenton. I'm coming down to Bradenton in the end of August. So
You're right here.
there
It's
you go.
you can meet Dick Vitale, who's in Bradenton and always at the restaurants. Anyway,
There
thank
you
you
go.
for this week.
All right. Well, yep. And that's going to do it for another edition of Fire Law Roundup. If you have listened to us all this way, please click like, please share, please help us increase our algorithm. We've been around now for 3 or 4 years. And, every click, every like, every share, every subscribe really helps our algorithm improve. And it's going to help bring us to the attention of more firefighters and more attorneys out there. Okay.